Hello everyone, I'm Steve Savant, syndicated financial columnist and money color commentator. On today's show, creditor harassment and credit scoring. Part 4 of our series on myths and material facts of bankruptcy with attorney Mallory Powers. Welcome to the fourth segment, Mallory.
Thank you.
Well, man, I know what it's like. I've had friends, relatives, harassment. I'm talking majorly on the phone, sending the sheriff to your house, knocking on the door. I mean, this is kind of hard. You know, you don't even want to pick up the phone.
Mm-hmm. Yeah, they can be relentless. Luckily, there are some laws in place now where there are time frames that creditors can call you and, you know, things that they can ask you. So there's some laws in place now that can help that out, but it can be brutal for a lot of people. Now,
until you actually file, they still have the right to call you. Is that not so?
Right. That's correct.
So now, even if you tell them you're threatening to file, until that happens, they can still call.
Right. There's an automatic stay that provision of the bankruptcy code that gets put in place, but not until you actually file the petition. So, but the second that petition gets filed, that stay gets put in place, and if the creditors are contacting you or trying to collect from you or trying to take your property after you file that petition, then they're in violation of that stay, and there's sanctions that can be had against them.
So do they, in your experience, do they back off right away?
Not always.
Is that right? They still push the law.
Yeah, sometimes the creditors can be, I don't know how to say it, I guess, but they think that the punishment is not bad enough where they can get away with it. They say, no, it's worth it, because if they are going to pay us something and no one's going to punish us, then we're going to get what we can. So it can be pretty bad for people. We've before filed sanctions in bankruptcy court against creditors for that reason.
So they're still pushing it. Do you ever have creditors come after your clients even after bankruptcy filed, settled, everything's done?
Yeah. We have clients all the time that come back and say, I received this letter. They were listed in my bankruptcy petition. I called them and told them I filed bankruptcy, and they're still coming after me. And again, you go back into bankruptcy court and you file for sanctions against them. And a lot of the times you get money for that as well, or you get your debt resolved if it wasn't already.
Okay, so, but most of the time, most creditors are going to, once they see the bankruptcy filed, they're done. They're not going to hassle you.
Most of the time, yeah.
All right, okay. Let's talk about, you know, everybody, I mean, Susie Orman, everybody's talking about my FICO score and, you know, my credit score from, well, and of course, what did we just, Equifax just got in trouble for dumping everybody's credit. Hopefully mine's not out there. You know, but I'm just saying, when we're looking at credit scores, everybody, this is the holy grail to a lot of people. I mean, you get loans. I found out about 2 years ago, your house and vehicle property casualty insurance looks at your FICO score to see how much they're going to charge you for your insurance. What's with that?
I don't know, but I've heard for jobs too. Jobs, they can look at your credit score. For renting an apartment, they'll look at your credit score. It's everything now. So
in bankruptcy, right? Let's say you were doing fine. You had a, let's say for discussion's sake, 725, which is a nice credit score. But now you've never been behind, but you're paying the minimum everything just to keep everybody alive. And finally, you just come to the place, I got to go. What kind of, I know this is a rule of thumb. It's not a, but what kind of number drop am I going to see? 200, 300?
We see between 100 and 200.
Wait a minute. I just filed bankruptcy and I'm only going to get a couple hundred points off my credit score?
Yeah. And most of the time, people who filing bankruptcy aren't in the 700s. I usually see them more in the 500s. So then you're going to drop down to maybe 4. 3, high 3s, something like that. And you're already low because you probably are already having some problems. That's why you're looking to file a bankruptcy.
So in credit scoring, how long, I mean, I know this is a little maybe outside your purview, but how long does it take me to get back to maybe some credible score?
Not that long. There are many programs out there that do credit rebuilding for you or help you with it. And
they're legitimate?
Usually, legitimate programs. And they usually say within 12 to 24 months you can rebuild. So I've seen it personally with certain clients that have been able to do that, been pre-approved for home mortgages after bankruptcy.
How long after, though?
2 years.
So they're still, now they're probably not getting the best rate, right?
Actually, I don't think it was too bad.
Really? Wow.
So it depends. That was for a pre-approved home mortgage. But for credit cards, you'll get credit card offers right after filing bankruptcy, before you even get your discharge. And that's because the credit card companies are just scouring the public records and looking for people who are now free of debt who can rack up more debt.
Well, somehow that sounds evil to me.
Yeah, it's not fair, but it does give you the opportunity to use that for your advantage. And even if you get a high interest rate, just beware of that and make sure you're paying it off every month. That helps you rebuild your credit score.
I have to say, in my short time in the earth here, it seems like bankruptcy has gotten much more benevolent to the filer than it used to be back in the day 40 years ago. I mean, it sounds like you're rebuilding. You're able to get back to normal in a couple of years. You can get a mortgage on a home. I mean, I'm sorry, but that sounds pretty benevolent.
Yeah. Well, I mean, I think a lot of it had to do with the crash in 2008, 2009. A lot of people were affected. So, I mean, they need to provide something to help everybody rebound. Because otherwise, all the businesses are failing. If they're not going to give loans to anybody, how is anybody going to continue with business? So everything is very debtor-friendly right now.
It is. Even after Dodd-Frank. That so surprises me because they really imposed, in my view, very tough sanctions on how to get a mortgage and who can get a mortgage and all that. So well, I'm happy that it can happen, just that I'm so surprised. Okay, now, so I'm in shock. I've just talked to my youngest child. You get out of school and they're just hitting them with credit cards.
Yeah.
Take this one there. Now you just told me I just filed for Chapter 7 and I'm getting besieged by everybody, whether it's Visa, MasterCard, American Express, Discover. They're okay with coming back to me even though I had a bad boy-ish episode.
Yeah. And, I mean, they're going to make money off of it because you either are paying off whatever you're spending, which is great for them, or if you're not, they're going to hit you with that horrible interest rate, and then they're going to try and collect it from you, or they're going to, garnish your wages after they get a judgment against you. So they're going to make money regardless.
I want to ask you about one thing that came up in your list of bankruptcy. You said this phrase that really caught my eye. If your bankruptcy was considered a no-asset case. Well, what do you mean by that?
So there are no-asset cases and there are asset cases. What happens is if all of your exemptions cover all of your assets or your property and there's nothing to be had for creditors, then it's considered a no-asset case. If, for example, you have a boat that's not exempt and the trustee wants to auction that off for the benefit of your creditors, then maybe she gets $5,000 to give to your creditors, then it becomes an asset case. And so there are different things that happen in a no asset versus an asset. An asset case usually takes longer. Okay, well, in your experience, and because this is all you do, you're an attorney, bankruptcy attorney, how many people are no asset out of the ones that you've personally experienced yourself? No asset. It's just a filing, they're done. I would probably say 65% are probably no asset. And then the other is an asset where there's something that we expect to be asset. But then it comes down to whether the trustee is actually going to take the asset to make it an asset case. So they have to actually... Could they rule then in your example of a boat, oh, that thing's so old and it's not really in that great a shape, I'm not even going to waste my time doing that. Right, they can. And so then if they don't actually take it to liquidate it, then it's not going to be an asset case. How much well, Mallory just brought up another question. How much flexibility do these trustees have to make the call here? They have a lot. So they have a broad brush authority here. They do. Wow, so he can walk in there and say, these items that are normally not exempt, are not exempt. I'm sorry, but they're so old or they're not in good shape or whatever. And he could just say to keep it cheap and just go non-asset. Yeah, a trustee isn't going to want to waste his funds to go after something that's not even going to cover the cost of it. Right. So they take into account those kind of things as well. Now, in your practice, I'm going to a bankruptcy attorney. If I have a no asset case versus an asset case, cheaper over here because I don't have anything really to worry about? It depends. It depends on whether there's some pre-bankruptcy planning to get to the no asset case or how much work is going into it. But there are attorneys that do that do, only that. Well, do fees based on whether it's an asset or no asset case. Well, I was just thinking in my mind, if I was managing your career and you said 65%, I'd be saying, hey, I only take no asset cases, in and out the door, and I'm done, Yeah. Well, okay, so that was that. If you turn over some property and money to bankruptcy,
your case was an asset case, the trustee could say, no, I'm not going to run that. I'm not going to work that out. And he has discretion. I mean, you say huge discretion.
Yeah, a creditor could probably object, but they usually don't. So the trustee can do what they want.
Pretty much what they want. Well, don't forget to watch our next segment on alternatives to bankruptcy. Thank God there is. Part 5 in our series on the myths and material facts of bankruptcy. And keep in mind, before moving forward with any of the ideas on our show, always check with your tax consultant, legal counsel, or your financial advisor. You've been watching Steve Savant's Money, the name of the game.